Hi, thanks so much for joining our webinar this morning. My name is Jessie Peterson. I am the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Ryan Suit, a Virginia construction lien law expert. Today's webinar topic is Don't Sign a Release Unless It Says This One Thing. So without further ado, I'd like to introduce the fabulous and wonderful Ryan Suit.
All right, thank you, Jesse. Good afternoon. As Jesse said, my name is Ryan Suit. I'm an attorney with Peder Coward in Virginia Beach, Virginia. This is my second webinar with SunRay. It's good to be back. To those who have seen me before, welcome back and thank you for joining. And to everyone here, I look forward to educating you all on releases in construction contracts in Virginia today. All right, so just some basics as we get into the webinar. If you have any questions, use the GoToWebinar chat box on the right. We'll get through these at the end. If you do have any questions, please don't include any names or company names in the questions. We just prefer everyone to be anonymous. And if you do have any other questions, Jesse will try to get to those during the webinar if you have any tech issues or things like that. So today's agenda, we're going to go through Virginia's mechanics, liens, laws as a refresher. Then we'll get into what is a release, where is the release, why you may need to sign it. We'll discuss statutes and case law in Virginia on releases and waivers. And then I'll have a few parting words of advice before Jesse gets into the resources that SunRay offers. So just as a refresher, here are some information on Virginia's mechanics liens. So a lien is a mechanics lien is a lien on a property that was somehow improved by either labor being performed or the furnishing of materials. So in Virginia, the parties that can file a mechanics lien is pretty broad. It's any person performing labor, furnishing materials worth $150 or more, which is a pretty low bar. It's also any person providing labor or materials of any value to condo units or limited common elements or for site development. And anyone in the contractor tier from a general contractor down to a material man or supplier can file a mechanics lien. In Virginia, the most important thing about mechanics liens is to follow the rules. They're very strictly enforced by the courts. The deadline to file a mechanics lien is 90 days from the last day of the month in which last work was completed, which is a mouthful. But basically, for example, if a contractor performed his last work on a project today, he would have 90 days from November 30th, the end of this month, to file a lien. Now in Virginia, we have the 150-day rule, which means that from the day that a lien is filed, it can only be filed for labor performed or materials furnished in the prior 150 days. So that means if you did work 6 months ago and are just now filing a lien, you can only file that lien for the work that was done in the past roughly 5 months. And if you include anything beyond that 150-day mark, it could actually invalidate the entire lien and make the whole lien unenforceable. That's a really important factor to consider. Once the lien is filed, it has to be enforced within 6 months of when it is filed, or within 60 days after the completion or termination of the project, whichever occurs later. So if you're only working at the beginning of the project and then file a lien, and the project goes on for a year, you could then file or enforce the lien within 60 days of when the project actually ends. Again, this is pretty technical stuff, so if you ever have any concerns or issues, consult an attorney to make sure you're protecting your lien rights. Now, getting into the real subject matter of today's webinar, what is a release? A release is a waiver of your lien or bond rights, or a waiver and release of your lien or bond rights, and however you want to phrase it. And ultimately, it's you giving up your rights to either file a mechanics lien or enforce a lien or file suit on a payment bond, depending on the project. Now, there are different types of releases. The first description I'll get into is a partial versus a full release, and that kind of is exactly what it sounds like. If you're signing a partial release, it means you're only giving up part of your rights and not everything. This is often done on projects that involve progress payments. So if you're paid in the middle of the project, you may sign a release that gets rid of your rights to file a lien on the work that was completed, but you maintain any rights to file a lien on any work that's not completed yet. Like I said, this often comes up with progress payments or any project involving multiple invoices. A full release is a release of any right for you to file a lien on the project. This is typically done in a project that involves one lump sum payment, or even on a progress payment job. At the very end of the project, you may have signed several partial releases, but the party making the payments may ask you to sign a full release at the very end. This always depends on the terms of the contract, and which can have tons of different variables, but you always want to make sure that the terms of any release you sign are clear and unambiguous. Getting into the conditional versus unconditional description, again, this is kind of what it sounds like. A release can be conditioned on different things, such as payment actually being made within a certain period of time. And so you may agree to release your right to file a lien if you get paid within 30 days. But if that 30 days goes by without receiving any funds, then that's a condition upon which the release is no longer valid, and you would have your rights to file a lien back. Again, that's just one example. There can be all kinds of different issues that come up. It just depends on the contract or the project. Now, if you do see an unconditional release, that really means that the release is valid no matter what. There are no conditions upon which you can file a lien if you sign the release. However, that's a pretty drastic term. And a drastic term in a contract like that could be deemed unconscionable, depending on what other language is used in the contract. And if that were the case, then that unconditional release would be unenforceable, potentially. You just always want to make sure it's clear and unambiguous, and if ever in doubt, make sure you consult an attorney. Now, where is the release? Typically, the release is going to be somewhere in the contract. It'll be a provision or a clause titled release or waiver or something along those lines. It's often in the payment section of a contract, especially in Virginia, because as you can see at the bottom here, in Virginia, releases and waivers must be signed after the work begins. And we'll get into that a little further in some other slides, but as a practical matter, what that means is you may sign a contract that says, here are the terms of payment, you have to sign a release, but that is not actually a release or waiver of your rights. Instead, once you start work and once you put in an invoice and expect to get paid, whoever you're submitting that invoice to would ask you to sign a separate document that would be the release or the waiver. Because again, in Virginia, any release of your rights has to be done after you start work. Now, why do you need to sign it? Kind of depends on where you stand in the contractor chain. If you're a higher tier contractor, a general contractor on the job, or if you have subs or supplymen working under you, the purpose of a release is to protect you from any future liens. If a subcontractor signs the release, then you have a valid argument in court as to why they are not able to file a lien against the property you're working on, which is just protecting your company. It also ensures that work is final by any subcontractors, because the lower subcontractor signing the release is incentivized to get their work done right the first time, because they're going to be giving up their rights. Another reason that a release might be involved before payment is that an owner may require it, because again, as I said at the beginning, a mechanic's lien is ultimately against the property that's being improved. Now, if you're a lower tier contractor, the main reason you want to sign a release or a waiver is to get paid. For better or worse, that's often just a requirement of a job. A contractor will not pay a sub or a supplyman until they sign a release. And there's really no other good reason to give up your rights to file a lien or sue on a payment bond, because those are strong tools to collect funds. And so unless you're getting money, you really should not be signing a release, but oftentimes you have to do that. That being said, a release doesn't necessarily get rid of all of your rights. As we kind of discussed, the partial and conditional releases don't just eliminate any rights you have, and it's going to depend on the language that's used in those documents. Even if you do sign a release that gets rid of a right to file a lien or to sue on a payment bond, there are other ways of recovering the funds that are due to you, such as breach of contract. An action like that is always on the table to collect funds. Now I'll get into some Virginia-specific things. For mechanics liens, this is the statute that specifically identifies when a contractor or subcontractor or supplier can get rid of their rights to file a lien or to file a lien here. So any right to file or enforce any mechanics lien may be waived in whole or in part, except that the party may not waive or diminish his lien rights in the contract in advance of performing the work. So again, that's why in Virginia, any release has to be signed after work is started. And then the code section goes on to say a provision that waives or diminishes lien rights in a contract prior to providing any work is null and void. This next code section refers specifically to payment bonds. Any waiver of the right to sue on the payment bond shall be void unless it is in writing, it's signed by the person whose right is waived, and is executed after such person has performed labor or furnished material. Now that's a little unclear as to whether it's just whether they started it or whether they have fully performed everything when it comes to payment bonds. I believe there's some case law out there that really makes it a question of fact of whether a waiver to sue on a payment bond was properly released or not. It's going to depend on your situation and the language in the contract to really figure it out. But that is a statute where that right to waive your rights stems from. So other relevant statutes, 43-17.1 is the statute that allows an owner to challenge a lien. So you can't just file a mechanics lien on a property and wait to enforce it whenever you want to. This statute allows an owner to bring the filer of a lien to court to challenge it. And oftentimes an owner will do that if they say that they have paid the lien or made payments that would make the lien invalidated, but the lien is still on the property, because it would have to be officially released from the record before the owner would be fully satisfied with it. The next two statutes I list on here, kind of getting into the weeds, but they're the requirements for bonding off liens. This is something that is often seen in pretty large projects that might require a payment bond to be provided. Not something we need to dive into too much today, but just something I wanted to make you aware of. Some other case law that's on here that's in Virginia, for a waiver of mechanics liens to be valid, must be supported by consideration. Now, this might be something that you see and say, oh, well, I need to be paid extra because I'm waiving my rights. It's not really that strong of a negotiating tool. It's more that it's a requirement of the release to have certain language saying that the waiver was supported by consideration. That's going to be in just about every contract, or every contract for a release or a waiver that's worth its weight. But it's not necessarily something that entitles you to a ton of additional funds. A lot of these will be for like $10 or some very small amount. The second case states that a waiver must be express, or if implied, must be established by clear and convincing evidence. It's just reinforcing the fact that any waiver of your rights needs to be totally clear and unambiguous. because otherwise it's just going to cause trouble, and obviously the courts have already addressed it. So when a lien is released, as I was saying, it's typically after it has been paid or discharged, and then the party that actually files and records the lien has to file a release of lien into the land records to prove that the amounts have been paid and that the lien is no longer enforceable or effective. A lien is also automatically released after 20 years on the property. Or if you file a lien but don't enforce it, then it's going to be still in the records but no longer enforceable. And a court can go ahead on its own accord and release a lien that's not enforced if it's not done so within that 6 months after filing or 60 days after termination of a project. Now, here are just a few other additional pieces of advice I'd like to provide. Always, always, always review the contract. You don't want to sign something and then have it backfire because you said you read it, but you didn't read it in detail, and one small sentence, totally catches you and gets you into trouble. Again, if you're ever in doubt, consult an attorney. Another thing that I've seen a couple times now is you want to make sure that your licensure is up to date and accurate and correct. Go ahead and double check it. Can't hurt. Because in Virginia, especially, contractors need to be properly licensed with DPOR, the Department of Professional and Occupational Regulation. You need to have your proper contractor class, and you need to make sure that the correct entity that you are working under and signing contracts for is licensed. I had a case where a principal of a company was personally licensed with DPOR, but the company itself was not. And it was the company that signed a contract to work on a project, but because the company was not registered with DPOR, it did not have a viable means to file a mechanics lien. And so you want to make sure that you're really dotting your I's and crossing your T's, so to speak, and that you personally are registered with DPOR, or your entity is, or ideally both. And you want to have this done prior to signing a contract and prior to any project starting. The last thing I'll mention is that you want to specify exactly what work you did. Make sure you identify your scope of work with specificity, so in detail. That way you make sure that you're being paid for exactly the work you did, and that in the future, say for in progress payments, if you did work for that first payment, and then you invoice for the second, and the contractor says, no, you did that, you were already paid for in the first, you have some documentation if you identify the scope of work with your invoice, essentially, because documentation can really be crucial anytime that disputes arise. So make sure you are identifying that. And with that, I'll turn it back over to Jesse in case anyone has any questions.
Well, first of all, thank you so much. You were incredible as expected. So you have provided a lot of really good information for everybody. Yes, we do have a question that has come through. Pardon me. I think this one is referring to the 150-day look back that you covered a little bit. It says, if my work was longer than 150 days, should I have more than one lien?
Yes. The short answer is yes. If you are going to have a project that long and you haven't been paid for, any work that has been performed, you would have to file a lien, really 150 days into the project in order to guarantee that a lien would cover all of the work you performed.
Okay, wonderful. Thank you for that explanation. The other question that came through, what if I make a mistake and sign an unconditional release and didn't realize it? Is there any way to still have my lien rights? I know you covered this a little bit, but they're specifically asking about lien rights.
Sure. So if you sign an unconditional release, typically you signed it, unless there was some kind of fraud or some misrepresentation that induced you to sign it without fully understanding the consequences, it's probably going to be enforceable. Now, if that, like I think you were inferring, Jesse, that's just for your lien rights. That's not the end of the road, even if that unconditional release is still enforceable. You still have breach of contract actions. You still may have other causes of action to collect funds. But the lien, filing a lien is a strong tool in your toolbox. So it's anytime you see an unconditional release, you want to make sure that you are positive about what you're giving away before you sign it.
Perfect. Yep, exactly. Make sure you guys are aware of what you're signing. Typically, if whoever you're contracted with is asking you to sign their release, it probably has wording that's going to protect them. So make sure that you read it. You can always do your waivers and releases through our site as well. So everybody kind of pay attention, make sure you are very aware of what it is that you're signing. That is all the questions that have come through. If anybody does have another question that wasn't addressed, please feel free to reach out to me and I'll be sure to answer any further questions for you. Can you go to the next slide for me, please?
Yes. Yep.
Wonderful. All right, so here are some of SunRay's resources to help you guys stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. There's deadline calculators, project information sheets that will help you guys get the information you need at the very beginning of your project, and asking the right questions. There's state lien laws. So remember, each state has their own unique lien laws. So if you're working in a different state that you haven't done work in before, check that out so you know what is expected, what those deadlines are, and you'll be able to kind of put in there all the information of what your role is, what type of project, etc., and it will tell you exactly what is needed. So check that out. If you don't mind, go to the next slide for me, please, again. All right, so if you don't mind, take a moment to give us a review on Google. We'd really appreciate it. It takes about a minute of your time realistically, but it helps us it gets this information to other contractors like yourselves or other suppliers, and it also helps us get some feedback from you all about potentially what information you guys might want to hear about in the future. So give us that feedback if you can. And then the last slide, if you don't mind. All right, and with that, that is all we have for you guys today. Thank you guys again for everybody who attended. We hope to see you at our next webinar. Thank you again, Ryan. You really are wonderful. I hope everyone has a beautiful and sunny day. Thanks, everyone.